Hello everyone, I'm Ankit and you're watching StudyIQ IS English. In our today's video, we'll try to understand why is hunger strike such a popular form of political protest in India. And the reason why we are covering this discussion today, no points for guessing, is because of Mr. Sonam Wangchuk. As you already know, Mr. Sonam Wangchuk is currently holding an indefinite hunger strike protesting against education policies of the government, and more importantly, he is also demanding for the Union Education Minister, Mr. Dharmendra Pradhan, to resign from office. Now, in middle of this political protest where he is undertaking hunger strike, the Delhi police on Sunday went to Jantar Mantar and picked up Mr. Sonam Wangchuk and shifted him to a nearby government hospital, that is Safdarjung Hospital. Now, this move done by the government, that is Delhi police, has actually raised concerns whether government is trying to crack down on such kind of a peaceful protest. But more importantly, this kind of an action by the government raises some very important legal question. First, is hunger strike a constitutional method of protesting against any government policy? And second, yes, if it is a constitutional method for protesting against government policy, does the government have the right to force feed someone and end their hunger strike? So this is what we are going to discuss today in our today's video, and the notes which I will be using for our today's session, you can also download them by going to a particular Telegram channel called as ATS Live, and while you're at it, please do not forget to subscribe to the channel also. So let us try to get the background based on why the government reacted in such a way. Now, few days before, a public interest litigation was filed in Delhi High Court, which sought urgent medical intervention for Sonam Wangchuk, and if need be, he should also be force-fed in order to end his hunger strike. Now, instead, what the Delhi High Court actually ordered, it stated that the Union government and Delhi government should ensure that Mr. Wangchuk's health was monitored daily by government doctors, and if need be, any medical intervention can be considered necessary if the government or the doctors want to provide it. Now, based on this direction by a two-judge bench of the Delhi High Court, in which the court observed that the life of every citizen is precious, and therefore it is government's duty to ensure that they enjoy their right to life. And based on this particular order of the Delhi High Court and advice of medical practitioners, the Delhi police actually shifted Mr. Sonam Wangchuk to a government hospital where his health can be monitored, because his health was deteriorating slowly and slowly. Now, however, what you need to understand here, the court did not direct authorities to force feed Mr. Sonam Wangchuk. Neither did the court order his removal from the protest site. So why did Delhi government remove him from the protest site? Because the medical advice wanted them to. Right? Now, in this regard, let us try to understand, is hunger strike after all legal or illegal in India? Now, hunger strike is not illegal in India because there is no law which prohibits a person from undertaking a peaceful hunger strike. So this, your right to peacefully conduct a hunger strike, actually stems from a provision of the Indian Constitution, that is Article 19. If you remember, Article 19(1)(a) of the Indian Constitution gives you freedom of speech and expression, and Article 19(1)(b) of the Constitution gives you a right to assemble peacefully without arms in order to protest against anything. Now, hunger strike for long has been seen as a constitutionally recognized form of peaceful political protest, although these are not your absolute rights. Rather, your right to conduct a peaceful protest, including a hunger strike, is subjected to reasonable restrictions which are given in Article 19 subsection 2 of the Constitution, in where the government, in public order, for security and other constitutional grounds, can deny you your right to freedom of speech and expression. Clear? Now, let us try to understand what are the historical judgments of the Supreme Court which actually has validated hunger strike as a genuine ground for peaceful protest. Now, Supreme Court has recognized fasting as a constitutionally adopted method of protest, deriving the legitimacy from the Gandhian movement in the pre-independent India. In the Ram Leela Maidan incident case, which happened in 2010s, earlier half of 2010s, where Baba Ramdev sat on a hunger strike against then UPA government, in that judgment, the Supreme Court stated that a hunger strike cannot be treated as unconstitutional just merely because it involves by the protester self-denial of any food. In 2021 also, Madras High Court gave a similar judgment where it quashed the criminal proceedings against a farmer leader who had participated in a hunger strike. The Madras High Court stated that your right to hunger strike does not mean that you're attempting suicide. These two can't be equated, and therefore your right to hunger strike is a constitutionally recognized right under Article 19 of the Constitution. Now let us try to understand, if your right to hunger strike is a constitutional right, then why is government intervening? You need to understand your right to hunger strike stems from Article 19. But at the other hand, Article 21 guarantees you the right to life. And it guarantees not just you but every person the right to life and personal liberty. And the courts have repeatedly stated that your right to life maintains an obligation of the state, that it cannot remain passive spectator if someone's life is in immediate or imminent danger. And therefore Supreme Court in many instances have tried to balance your right to protest and your right to life in various forms. Let us understand many cases in which it has been done. For example, in 2024, a farmer leader, Mr. Jagjit Singh Dalewal, was undertaking a hunger strike as a part of farmers' protest. So there, the Supreme Court stated that his indefinite hunger strike means that there is a bounden duty on both the Union government and Punjab government to provide immediate and adequate medical care. At the same time, the administration should ensure that they should provide medical assistance without forcing the protester to break his fast, and unless it becomes imperative to save his life, no kind of medical treatment should be given without the protester's explicit consent. So what does it mean? Let us try to understand it. Now, this principle based on which the court allows the government to intervene actually is called as a parens patriae principle. It means the state assumes the role of a guardian when somebody's life is at serious risk, and the Delhi High Court's judgment allowing for medical attention to be given to Mr. Sonam Wangchuk actually follows a very similar approach. It allows preservation of life, that is maintenance of Article 21 of the Constitution, while avoiding unnecessary interference with the protest itself. So it tries to balance your right to peacefully protest again under Article 19 subsection 1 of the Constitution, and it also balances it with Article 21 of the Constitution. Now, does it mean if a person is undertaking hunger strike and if his life is in danger, does it mean the government reserves the right to forcefully feed a hunger strike participant? Let us try to understand it. Now, there is first of all no specific Indian law that allows the authorities to automatically force feed someone who is undertaking a hunger strike, nor has the Supreme Court actually laid down a blanket rule which allows or prohibits the authorities from forcefully feeding someone. So when can authorities forcefully feed someone? Well, it depends upon multiple different factors. First factor is what is protester's medical condition, whether the protester is in state custody or not. What is the medical assessment of the doctors, and what are the court directions? So based on these factors, can the state evaluate or can the courts direct the state to forcefully feed someone? So what has been the government's approach in past times? Let us try to understand this. I'm sorry. Now, in Wangchuk's case, you need to understand neither the Delhi High Court nor the Delhi police has stated that he will be forcefully fed. Now, the court has directed that daily medical monitoring should be done of Mr. Sonam Wangchuk, and if need be, necessary medical intervention can be provided. And therefore, the police have shifted him to a hospital because of his deteriorating health and based on medical advice. But whether can the doctors or can the hospital administer any medical treatment on Mr. Sonam Wangchuk, that is subject to Mr. Sonam Wangchuk's consent. And this remains a very complex and ethical situation because there is no law, there is no direction by the Supreme Court to allow or to prohibit forcefully feed a hunger strike participant. So what can government do? In this regard, let us try to understand what the medical ethics actually suggest. Now, there is a medical ethics based on World's Medical Association Declaration of Malta on hunger strike. It states that the force feeding of a mentally competent person who is voluntarily refusing to take food is ethically unacceptable. It means if a physician should rather respect an informed refusal for a treatment if that decision could even if that decision could result into a death of a victim. Now, this medical ethics actually creates a problem for the state, As I told you, the state has to balance your right to peacefully protest with your right to life, and state has an obligation to intervene in case if your life is in danger. On one hand, this is what the constitution suggests. On the other hand, medical ethics say that you should actually respect somebody's consent. If the person wants to not take food, you are not allowed to give him food, even if it is forcefully. So what should be the way forward? Let us try to understand it. Now, what has the courts and government, or how has the courts and government dealt any instances of hunger strike before this Mr. Sonam Wangchuk's hunger strike? Let us try to understand this. Now, the reaction of the government and courts actually differs based on specific circumstances. For example, the Supreme Court, it has consistently encouraged the governments to engage with hunger strike participants. Rather, the state should not take a hostile approach. So what happened in Ramlila Maidan case incident, where Baba Ramdev was undertaking a hunger strike? Before hunger strike, the Prime Minister at that time, Mr. Manmohan Singh, actually wrote to Baba Ramdev urging him not to proceed with his hunger strike. And while he was in hunger strike, senior union ministers met him to persuade him to give up his hunger strike and participate in a dialogue with the government. So what has Supreme Court directed before? Supreme Court has directed the government to engage with the participants of hunger strike rather than not to end these kind of hunger strikes abruptly. Now, has there been an example of force feeding someone in the history of independent India? The answer is yes. If you remember, Manipuri activist Irom Sharmila, she was protesting against the Armed Force Special Powers Act for 16 years, and she had been repeatedly arrested under the then Indian Penal Code and was force fed through a nasogastric tube. Now, why was she force fed through a nasogastric tube? The answer is very simple, because at that time Miss Irom Sharmila was under government's custody, and that makes that force feeding instance very different from force feeding a public protestant like Mr. Sonam Wangchuk. By contrast, if you look at it, the popular movement against corruption in 2011, which was spearheaded by Marathi activist Anna Hazare, here his protest was allowed to continue under medical supervision, but without any instance of compulsory feeding. Now, you must be thinking, why is hunger strike so popular in India? So much so that government, under extreme even if not without extreme circumstances, does not forcefully feed any kind of protestant. The answer is very simple, because fasting in India has a deep cultural as well as religious roots. But fasting as a form of political protest actually was made popular by Mahatma Gandhi, who transformed it into one of India's most powerful political tools. Gandhi, when he arrived from South Africa into India, he participated in many instances of peaceful hunger strike, where Mahatma Gandhi wanted to use hunger strike as a weapon to awaken someone's moral conscience, not just of society but also of the state. Now, you need to understand, to get your demands met, there are multiple different ways to do it. One of the ways to do it is to undertake violence. But we all know Mahatma Gandhi was not a, what you can say, someone who encouraged violence. Rather, Mahatma Gandhi followed strictly the principles of non-violence. So in order to meet his demands, in order to get his way, Mahatma Gandhi relied on methods of protest, in which hunger strike was one of the key methods. In hunger strike, Mahatma Gandhi underwent his own cycle of suffering, which meant after seeing suffering, it would awaken the moral consciousness of then colonial government. And this action, or the success of Mahatma Gandhi's hunger strike, actually was one of the important reasons why India got independent. But even after India got independent, in many instances we have seen many people undertaking hunger strike, for be it demand for linguistic states, be it prevention of land acquisition by the state, or against corruption, ensuring farmers' rights, and even for environmental protections as well. Once, one of the popular protests that was done few years after India got independent was done by a Congress worker, Potti Sriramulu, who was demanding for carving out of separate state for Telugu speaking people from erstwhile Madras state. Now, after he underwent a hunger strike for 58 days, which unfortunately resulted into death, it ultimately led for creation of first linguistic state in India, that was Andhra Pradesh. Similarly, as I told you, Manipuri activist Ms. Irom Sharmila prolonged fast against the Armed Force Special Powers Act actually became an international symbol of resistance in a democratic country. So did Mr. Anna Hazare's fast, which galvanized anti-corruption movement in 2011, which ultimately resulted into fall of UPA government in 2014. But is hunger strike universally accepted in India? Has it been universally accepted by each and every form of popular public figures in India? The answer is no. One of the first criticisms that went against hunger strike was by Mr. Dr. B.R. Ambedkar, who was one of the founding fathers of India's constitution. He termed peaceful protest like hunger strike as an instance of grammar of anarchy. He stated that hunger strike was acceptable when you were protesting against a colonial government, which was not at all a popular government. Rather, after India got independent, when you got constitutional methods to seek a political change, fasting unto death and civil disobedience should actually give way to more and more democratic processes. On the similar lines, Mr. Pratap Bhanu Mehta also states that fast unto death actually becomes coercive because it forces an enormous amount of pressure on the governments. Therefore, it has not been universally accepted as a method of peaceful protest. But say whatever, be it good or bad, we cannot deny the fact that hunger strike remains very politically potent, because here the protester is undertaking deterioration of his body and it becomes a visible symbol of suffering, asking both the governments as well as the society to react. Why do you think Sonam Wangchuk's protest has become so popular? Because he's undertaking suffering because of the peaceful hunger strike. And therefore, this case against brings up a very important question. Indian courts have repeatedly held that it is your right to peacefully protest and it deserves protection from states' arbitrary action. But at the same time, you have to understand that the courts have also insisted that states cannot remain a passive witness to a citizen's life if it is in imminent danger. Understood? So this has been the reason why hunger strike remains so popular in India. It started from Gandhian culture of Satyagraha, and even after India got independent, we have seen many successful and some unsuccessful instances of hunger strike. Because hunger strike, when a protester is suffering, it creates a moral obligation on the state to adhere and at least accede to its demands, right? Now, before we end up our today's discussion, there is an important question. Now, the topic that we dealt with is a very important part of fundamental rights, where we covered Article 19 as well as Article 21. If you see the questions that appear in UPSC exam, you'll realize polity, history, economy, and geography. These are the four important subjects of UPSC. In addition to that, all the other subjects which are important for UPSC, classes of them are held in our foundation batches. In our foundation batches, up till tomorrow, that is 21st of July, they are offered at an extremely discounted rate of 7,999. Take admissions right now, and if you use the code ATS Live, you are going to get this best possible rate. Now, before we end up our today's discussion, there is a question that appeared in 2018 on your right to privacy. On similar lines, I've created a question that suits our today's discussion. Do read this question. Right to peaceful protest is recognized as an important democratic freedom under the Constitution. Which one of the following provision correctly and appropriately implies the above statement? Do let me know the correct answer among these four options in the comment section. And what do you feel about hunger strikes in general? Do not accede to what the political parties X or Y have an opinion on it. Do give me your opinion, which you might have developed by watching this particular video. Please let me know your opinion in the comment section. And before we end up, this is the question. This is where you get the notes which I've used in our today's session. The channel's name is called as ATS Live. So this is all from my side for today. Please have a very good day. We'll see each other again quite soon.